Okay, Shannon, you can put us on the record now.
Go ahead, Judge.
Okay, this is the matter of Rohrig versus Michigan Department of Corrections. Mr. Marco for the plaintiff, Mr. Asbenson for the defendants. And Mr. Asbenson, if you did file a reply to the motion, I did not see it. I've been working from home this week. We had a exposure incident in my courtroom last week, and I'm required to stay home for 10 days. So here I am. Welcome, welcome into my dining room.
I did file a response on Tuesday, 3 days.
I'm not surprised. I guess the one thing, maybe you've already done this, but one thing I can recommend to each of you, when you do file something with the court, send a digital copy to either my secretary, Patty Clark, who handles civil matters, or to my clerk. Although if you send it, Peter's gone these yesterday and today. But if you did it on Tuesday, he would have gotten it and he could have forwarded it to me. But in any event, Mr. Marco, I've read your motion in brief, and I understand your position. Let me hear from Mr. Asbenson.
Of course, Your Honor. Thank you. I'd like to take this opportunity, I suppose, to take a slightly deeper dive into the case of Hammond versus Wayne County. This is a 2004 case that's basically on all fours with the present case. The parties in that case were Wayne County, Warren Evans, and the Wayne County Sheriff's Department. The claim that was brought in that case, and that's very similar to Ms. Heidi Washington being named in the present case, because Warren Evans was the sheriff of Wayne County at that time, though he was named as Warren Evans, just like Heidi Washington is named in this lawsuit as Heidi Washington. That case was also a civil rights case. The plaintiff brought a claim of that she had been sexually assaulted while in the Wayne County prison. And she requested the deposition of the current and the former sheriff of Wayne County. Now, one of them was a party to the lawsuit. Wayne County moved to quash. The plaintiffs argued that the former sheriff should be deposed because the deputy who had allegedly committed the assault had been disciplined 14 times, and these disciplines had not been produced in the litigation. And all of the disciplines were reviewable and appealable to the sheriff. And so they argued that the sheriff would have knowledge of these disciplines and they needed that information. There was also communication to the sheriff, and those were their two arguments for why they should depose the former sheriff. Then with regard to Evans, who was also a party to the lawsuit, they claimed that he knew of sexual improprieties committed by the jail employees, and that this demonstrated a pattern and practice of such deprivations of rights at the prison, at the jail. The sheriff also, they argued, plaintiffs, that the sheriff directed changes be made to jail policies and procedures. The trial court denied the motion to quash, but the Court of Appeals reversed, applying an abuse of discretion standard of review. On appeal, Wayne County argued that the depositions were not essential to prevent prejudice or injustice. And the Court of Appeals held in 2004, so relatively recently, that high-ranking public officials may not be compelled to provide deposition testimony, and remember that Mr. Evans was a party to that lawsuit, unless or until a preliminary showing is made that the deposition is necessary to obtain relevant information that cannot be obtained from any other discovery source or mechanism, not just source, but mechanism. And the Court of Appeals goes on to say, i.e., that such a deposition is essential to prevent prejudice or injustice. The purpose of this heightened scrutiny is to strictly limit the intrusions that would burden a public official's effort to advance the effective and efficient operation of the public agency. And they go on to say that interrogatories are an appropriate mechanism to answer these questions. In this case, plaintiff suffers no prejudice by not deposing Director Washington. They've gotten all the answers to their questions, and attached to my response was a statement from Heidi Washington providing her knowledge. The problem is plaintiff just doesn't like the answers that they've gotten, but that's not a reason to depose them. That deposed Director Washington, that does not show prejudice or that injustice will occur if they don't take Director Washington's deposition. If any questions remain, Mr. Marco still has interrogatories that he can propound to Director Washington. The burden of deposing Director Washington, additionally, is not just for however long the deposition lasts. Mr. Marco is a very competent deposition attorney. I've sat through his depositions. He's excellent. And you have to show up to those depositions prepared. So the time of the deposition is not the only time that we're talking about. And additionally, we're in the middle of a pandemic that has hit the Department of Corrections rather hard as this virus spreads through indoor contact, and there are thousands of prisoners indoors. Last time we were here, and I rewatched the hearing last night. We got a copy and I rewatched it last night. Judge, you asked Mr. Marco, is it your contention that the director actually directed the retaliatory acts be taken against these plaintiffs? And Mr. Marco's answer was yes, along with Kathy Warner. But since then, Your Honor, Mr. Marco has been able to take the deposition of Jennifer Nancy. During this deposition, Ms. Nancy testified, and this is in Exhibit 7, pages 17 through 19 of plaintiff's brief. Ms. Nancy testified, I'm the ultimate decision maker. I simply consult and confer with the director, and in this particular case, it was my decision to discharge. Mr. Marco asked Ms. Nancy, and so did you tell the director in that what did you tell the director in that consultation meeting? Ms. Nancy responded, I honestly don't recall the specifics. It was quite a long time ago. I do recall that my position was discharge. I would have explained to her my rationale for the discharge, and we would have discussed it. Then ultimately, obviously, the decision was discharge. I signed off as discharge. Jennifer Nancy was the one who discharged the plaintiff. There are two claims in this case. Both of them are retaliation claims. Both claims of retaliation require causation. There's a retaliation claim under ELCRA and a retaliation claim under 42 USC 1983. Both of them require causation. The only adverse action here is the termination. Ms. Nancy went into her meeting with Director Washington thinking, I'm going to terminate the plaintiffs. She left that meeting with the same exact intention. There can be no causation because her mind wasn't changed. The director had no influence on that decision. It was not the director's decision to make. By policy, it was Jennifer Nancy's decision to make. Director Washington's testimony is not relevant because it was Jennifer Nancy's decision. The only reason that Ms. Washington, Director Washington, is named personally in this case is so that plaintiff can plead in avoidance of governmental immunity. The individual capacity or official capacity is more of a federal court distinction. And that's specifically relevant to 1983 claims, which is one of the claims that Mr. Marco has listed in this case. And the only way that you don't get kicked out on a C8 or a 12B6 if you're bringing a 1983 claim is to make allegations against the official in their individual capacity. Otherwise, it's kicked on governmental immunity. It's barred. That's the only reason Director Washington is named individually. And then to get into the details of the emails in this case, all of the emails that Mr. Marco references in this case were all sent after the investigation started. These are emails that Mr. Rohrig has made after he knows he's under investigation. Now, Your Honor, this is after these investigations that are the basis of this lawsuit is after Mr. Rohrig was on a 15-day suspension. And that 15-day suspension was for correspondence that he had with an African-American MDOC employee. Now, they did not work at the same facility, but these text messages that Mr. Rohrig sent and Facebook messages that Mr. Rohrig sent to this African-American MDOC employee, Mr. Rohrig alleges that they occurred after this individual allegedly tried to hook up with his wife. But in these text messages, Mr. Rohrig calls this other MDOC employee the N-word no less than 17 times. And I mean, I hate to read some of this out loud, but these text messages are things like, "Fuck you, boy. Come and get some, N." I don't even want to say the word. "My fucking hogs would choke on your ass, but they would get it done. Fuck cheating N's. Herpes N's." And then the Confederate flag. He used the N-word 17 times, and that's just a sample. I don't want to go through all of it. He got a 15-day suspension, and he was lucky that he wasn't terminated for that. Now, immediately after he sends these text messages, and immediately after he comes back to work from that 15-day suspension, that's when he starts reporting everybody who was involved in that discipline. That's when he starts reporting, making claims that he's being mistreated. His EEOC complaint, which was filed after it was filed because he received discipline for that charge. His EEOC complaint spawned many investigations into many MDOC employees, most of which they were found to be baseless charges. During one of the subsequent investigations that he got going, that Mr. Rohrig got going, it was one of his coworkers mentioned, Mr. Rohrig, in response to this FOIA request, he said, "If you delete emails, then Lansing can't see them." You know, he's supposed to be gathering emails that were responsive to a FOIA request that was directed to him. And lo and behold, the investigator who went into that found that he had deleted emails. They were emails that put him in an unfavorable light. And so it's during those investigations that were the result of his actions, his reporting alleged mistreatment of him. It was during those that he starts sending these other emails to Director Washington, to the FBI, all of these emails to protect his own job. It's not that MDOC retaliated against him. All of the investigations, the 3 emails that Mr. Marco attaches to his brief, all occur after every single investigation in this case had already started. It's not that Mr. Rohrig was retaliated against for sending these emails. The train had already left the station. The investigations had already started. The first 2 emails were sent by Mr. Rohrig the morning after he attempted to intimidate his African-American superior and his African-American investigator on Facebook. He accused them of work rule violations and the investigator's ex-spouse of smuggling drugs into the facility. Now, one of the interesting things is he says that, you know, it's been known for a long time that the ex-spouse of his investigator was smuggling drugs in. And eventually he was caught, the ex-spouse, and he was terminated. But at that time, the investigator and the ex-spouse had been separated for quite some time. It was merely an attempt to intimidate the investigator by Mr. Rohrig. and Mr. Rohrig sends these emails to Director Washington the morning after he sends those Facebook posts to his superior, accusing his superior and the investigator who is investigating him of wrongdoing. So he's sending those emails as a CYA. And then with regard to the third email that was sent even later on, Stephen Marschke, even, who plaintiff loves to talk about, Stephen Marschke wrote, and this is in Exhibit 10 to plaintiff's brief, he writes, "I'm sure this is a direct result of Rohrig's interview yesterday with investigator Nick Cusack. He was in the final stages of his investigation. The investigation against Rohrig by IA investigator Lachelle Fuller was processed this week." And so the email that is Exhibit 10, Mr. Marschke is even saying, yeah, the only reason, Director Washington, the only reason that Mr. Rohrig's complaining to you is because we're investigating him. Again, this is not MDOC retaliating against Mr. Rohrig. This is Mr. Rohrig trying to make a case when he doesn't have one, because he knows after he got a 15-day suspension, he's going to get terminated when he screws up next. And he just got caught deleting emails that were responsive to a FOIA request. Now, with regard to the memos, all of the latter two memos are both talking about Kathy Warner, and they're both from after Mr. Rohrig was terminated. In fact, 2 years, like 2.5 years, something along those lines, after Mr. Rohrig was terminated. Mr. Rohrig was terminated in May of 2000, 2 years after he was terminated. So they don't have anything to do with Mr. Rohrig's case. There's nothing, there's no memos, there's no report by Mr. Marschke prior to these two memos in 2018. There is no other evidence that Kathy Warner ever changed or request to be changed the outcome of investigations. And there is zero evidence that Ms. Warner ever changed a result from guilty to not guilty. The only allegations in these two memos is that Ms. Warner changed the outcome of one case from insufficient evidence, meaning we don't have enough evidence to move forward, to no evidence. It's not guilty to really not guilty. And there's evidence that she requested that the outcome of her own investigation into her was changed. There's allegations that she asked for it to be changed from insufficient evidence to no evidence, but that never happened. Director Washington's statement that I attached to my response indicates that she told Kathy Warner, "You need to make sure that you vote your own." And that
Say it again.
you need to vote your own on these cases, because Kathy Warner had the ability to make a vote on these cases, make a determination. So the director told her, you need to make sure to vote your own, and that Steve votes his own, so that there's a record if you guys disagree. That's fine if you disagree. Kathy overrides Steve if they disagree, because she's his boss. But the director just said, vote your own. And there is no evidence in the 2.5 years that Stephen Marschke remained at the department before he left on his own terms for a voluntary retirement, and he's now having a great time in Florida and Mexico. But there's no evidence of any complaint after these two memos, which occur 1 week from each other. That matter was dealt with. It's done. There's no evidence prior to those memos of Kathy Warner ever making these kinds of changes or requesting these kinds of changes. And Mr. Rohrig was disciplined 2 years prior. Now, the first memo that's attached does address the Rohrig case. But all that this memo is a memo being sent by Marschke to Director Washington, relaying some concerns he had that Kathy was micromanaging internal affairs. And this is something that you see throughout Mr. Marschke's career. He does not like the management style of Kathy Warner. and he routinely complains that she is micromanaging. He doesn't like her oversight. He doesn't like that she wants to know what's going on. This memo arose because Mr. Rohrig sent emails to Stephen Marschke and Director Washington. So Director Washington was asking Kathy Warner, what's going on with this case? Why am I getting these emails? And she forwards the complaints that Mr. Rohrig makes onto IA. And so this is merely Mr. Marschke doing his own CYA, saying, if Kathy Warner ever complains I didn't tell her about something, you know, I forwarded everything on to you. There is nothing in that memo that hints that Kathy Warner interfered with the Rohrig investigation, that she changed the outcome of, that she had any influence on the case. Just that she shouldn't be micromanaging Mr. Marschke. And Your Honor, attached to my response, and I can go ahead and go through it in more detail if you would like, but is a statement by Director Washington stating her knowledge. She, unlike what Mr. Marco claims, she was not the point person for these complaints by Mr. Rohrig. All she did was she received some emails from Mr. Rohrig and forwarded them on to IA. He asked Kathy Warner what was going on with this case. And Your Honor, Director Washington in her statement says that she doesn't even remember if Kathy and her ever ended up discussing the case. She doesn't have any knowledge worth discovering in a deposition. And plaintiff must meet a very high standard, according to the Court of Appeals, to depose the director of a constitutional office, which Director Washington is.
If this matter goes to trial, will Director Washington be called to testify?
I do not plan to call her in my case in chief. I mean, if there's allegations that she's out there murdering puppies, I could see needing to call her as a rebuttal, but I don't anticipate her calling her in my case in chief. I mean, it's a little bit early still to exactly nail down what witnesses, but I don't anticipate calling her. I don't see any relevant information that she has.
Well, the reason I ask the questions is I can't imagine that I would allow you to shield her from a deposition and then turn around and allow her to testify. It would have to be a very, very unusual circumstance. And what I would probably do is stop the trial and allow a deposition to take place before I would allow her to testify. There's no way in the world I would let her testify without the plaintiff having an opportunity to depose her before she testifies.
Well, and Your Honor, I cannot think of a employment trial in which she has been called to testify. And I don't see anything different in this case than any other employment trial.
All right, let me hear from Mr. Marco.
Yes, Your Honor. So you're familiar with this issue because we were before you on December 15th, 2020. I'm not going to go over and argue, jury arguments here that sound more like an opening statement, but I can tell you that the facts presented to you by Mr. S. Benson and the facts that we're going to present to you, I'm sure at a motion hearing, are starkly different. What we can present to you and what we do know, and by the way, an arbitrator determined that Mr. S. Benson's narrative was false. The facts that he told you, an arbitrator heard the facts, determined that Mr. Rohrig didn't do anything wrong. And in fact, if it wasn't for him, there would still be a drug mule smuggling drugs into the Michigan Department of Corrections and giving it to prisoners. But that's not relevant for this motion. As you recall, on December 15th, 2020, you stated that you were inclined at that time to allow the deposition to go forward, but you wanted some certain things to happen, specifically the deposition of Jennifer Nancy, which we took in January of this year, and of Kathy Warner. And I think those depositions are very telling. Remember, this is an employment discrimination case, Your Honor. Miss Washington, Director Washington, is a named defendant. And she's not a named defendant as a throw-in, you know, like in this Hamed case that Mr. S. Benson's referring to, which, by the way, was overturned. It was reversed, the case that he's citing. But in that case, the head of the jail was a throw-in on a Manel type claim, a policies and procedures type claim. In this case, Miss Washington has direct involvement, documented, and decision-making with regard to the terminations of the plaintiff, Mr. Rohrig. And we can prove that because it's in writing. So let's talk about why we need her deposition and what she did. So first of all, just so you understand, she is the head of the department, obviously, but directly under her is Jennifer Nancy. Directly under her on the other side is Kathy Warner, who's her executive assistant. So Kathy Warner's office is right next to hers, and she goes in and takes orders. These are the foot soldiers of the director. Stephen Marski's office is down the hall in the same building, and he takes orders directly from the director. So in this case, why do we need their deposition? And I've attached, that's why I created such a massive record in this case. So number one, Mr. Rohrig is reporting things directly to Director Washington in emails, complaining and engaging in protective civil rights activity. Judge, I know that you have an extensive experience doing employment law as a private practitioner. You have to, as part of our retaliation claim, we have to show that Mr. Rohrig engaged in protected activity. And then as a result, there was a causal connection between engaging in that activity and being an adverse employment action, which in this case is termination. So the activity is in part direct complaints to Heidi Washington. Obviously, what she did with those complaints, how she handled them, how she felt about them, what she told people about them, what she did in reaction to them is critical to establishing that causal link, because Mr. S. Benson has already told me he's going to be filing a motion to dismiss. Presumably, he's going to be filing a motion to dismiss everybody, which includes Miss Washington. And we have individual liability claims against her under both 1983 and under individual liability under the Elliott Larson Civil Rights Act. So Mr. Rohrig is complaining directly to her. She's receiving these emails. She's doing things with them. And specifically, Judge, I asked both Miss Nancy and Miss Warner, you know, tell me what the director did in response to these. Tell me how they came on your plate. They said, we don't know. We have no idea. They said, you need to go ask her. And I tried to pick out the most salient testimony for you on page 7, where I specifically asked them, because I'm being prevented from taking her deposition. I'm trying to do the best that I can with these lower witnesses. So that's number one. That's a huge area of inquiry there. Number two, and I think most damning and most important, is you have the Director of Internal Affairs writing a memo with the subject line of my client. The subject line of the memo to the director is Brent Rohrig, and the head of Internal Affairs is writing a memo on a weekend to the director stating, I have serious concerns over how people are handling Brent Rohrig's case. This is before he's disciplined. Okay, so I mean, this is a smoking gun memorandum to the director, and we don't know what she did with it. We don't know. I asked Miss Nancy, I asked Miss Warner, and they said we didn't even know that these memos existed. Okay, that's number two. That's very important. And then number three, you know, Mr. S. Benson tries to distance the director and make it so like, you know, she's in this ivory tower and doesn't have direct involvement in what's really these decisions. That's completely belied by the evidence. Specifically, both Warner, Marski, and Nancy, direct reports to her, whose officer next door says she made the decisions. They carried them out, but they did what they were told. She's the ultimate decision maker, and they did what they were told. So I need to be able to explore these issues. The type of standard, let's talk about the law a little bit here, Judge. The type of standard that Mr. S. Benson is advocating for would make it impossible to ever take a highest decision maker at a governmental entity ever. Because in this case, we have direct evidence she made the decision from the testimony. We have evidence in documentation to her. And then we have everyone else saying, I don't know what she did. I don't know what she did with it. If we can't take the deposition in this case, there would never be a situation where we would be able to take, they would be immune. You could essentially say, have the director make the adverse employment action. They'll never be able to depose her about it. Everyone else can claim they don't know what she said. And we would essentially, it would immunize from liability. And there's no case that he can cite to you anywhere in America, not just Michigan, but anywhere in America where any court has adopted that standard, ever. And if you look at the cases cited by him, this Fitzpatrick case and this Hamed case, which was reversed by the Michigan Supreme Court, in the Hamed case, the Court of Appeals said that in order to shield someone like Heidi Washington, they have to show three things. Number one, that the deposition was not necessary for the administration of justice. Okay. Number two, that the director in this case had, quote, no personal knowledge of the disputed issues. And number three, that other discovery resources and mechanisms were available and the plaintiff didn't do them. That's not the case here, Judge. In Hamed, they didn't depose any lower ranking officials. In Hamed, the head of the jail had no idea about the direct facts. It was just a policymaker. So if we were just asking Miss Washington, Director Washington, about what are the general policies about the Department of Corrections, generally what happens, they would have a really good argument under Hamed. That's not the case here. She had personal direct involvement in this case from the beginning till the end, and we have evidence of it.
Let me stop you for a minute, because something you said, if I heard Mr. Asbinson correctly, is direct odds with what he told me, which was that Jennifer Nancy has testified, this was my decision. I made this decision. And yet you said everybody's pointing the finger at the director and saying the director made the decision. I got a big disconnect here.
Yeah, so Judge, let me explain how this works. And this is every single employment case with corrections. Okay, their defense at trial is everybody has their own little job description and position. Nobody's responsible for anybody else. And so whenever you try to pin someone down on who does something, they point their finger at somebody else. They say, that's not my department. So what Miss Nancy did say is that she is the discipline coordinator. So the form that ultimately will say, you are fired, Mr. Warrig, she signs off on. And so she will say, and she did testify, that ultimately she signed off on the paperwork that was put into the big Department of Correction machine that ultimately terminated Mr. Warrig. That's true. But what the Department of Corrections always looks over is how that decision was made and how that piece of paper was signed. So what she said is, if the director tells me to do something, I have to do it. If the director makes a decision, I'm certainly going to follow that decision. So while Miss Nancy signed off on the paper, she also testified that she discussed it with Heidi Washington, and that Heidi Washington's directives on things such as terminations control. So in other words, if you have, if I tell my office manager, I want you to go fire the attorney in the office, he screwed up a case. And she goes and fires that person at my directive. And I do it because that person's African-American or because they've been complaining about civil rights activity. I am still liable. You can't skip over that point. And I can't immunize myself by saying, well, the office manager did it. She was the messenger. She signed the form. And so that's what happened here. You have Mr. Marsky telling Washington, we got a problem here. I don't feel comfortable about what's going on. You have Rohrig going directly to Washington, engaging in the protected civil rights activity. And then you have the people who are the foot soldiers, like, you know, who work directly next door to Washington, taking instructions from her and having conversations with her directly about Brent Warrig. This isn't an esoterical thing, Judge. This isn't just generally. They specifically had conversations about Mr. Warrig and about his termination with Director Washington. And I understand your concern about, well, maybe Mr. Markle will just, you know, say they can't call her at trial. Okay, but that raises some other issues that we need to, I think, look at. Okay, if she's at fault in this case, at least under our theory of the case and under the evidence that we have, how is that going to play out? Because I'm entitled to a jury instruction that says failure to call witnesses. So if the witness in this case, you know, it would be like the Wizard of Oz, right? She's the person behind the curtain making all the decisions that are being carried out. And if we go to trial, I'm going to be able to point and say the person behind the curtain who you've never seen here, and then you're going to have to give me an instruction, Judge, that says that they failed to call the wizard, Director Washington. They failed to call her at trial. And if they want to do that, and we want to do that, that's their decision. But I don't want a situation where we go to trial and I don't get to do that. So maybe the wizard doesn't.
Okay, but let me ask you this. Do you honestly expect to get anything out of this director other than a complete denial? I had nothing to do with it. I didn't make this decision. I didn't make this call. I didn't influence the decision. And hasn't she in fact given a statement to that effect?
Well, she gave an affidavit that does not address, I mean, it's not a very long affidavit. It does not address all the areas of inquiry that I would do. And as we know from doing this, often affidavits can be taken out of context. What do I expect? I have no idea. I certainly didn't expect Stephen Marsky, the head of internal affairs, to tell me that he had been writing these confidential memos complaining about corruption and specifically complaining about his feelings that there was untoward things going on in Mr. Warrick's case. I mean, I almost fell out of my seat. I don't know what she's going to say. Maybe she'll deny everything, in which case that creates right there. That's helpful, Judge. If she goes and denies everything in this case, then how is that going to square with the testimony from the other people that they had given her all this information? You didn't do anything, Director? You're getting memos from your head of internal affairs stating that there's problems with this investigation, that he's concerned about manipulations, that he's concerned about corruption, and you didn't do anything. I mean, either way, it's going to be helpful information for this case. She can deny everything, in which case she's the director and did nothing, to a report by the head of internal affairs of the state's largest agency that there is rampant corruption regarding investigations, including the one with my client. Or she can say, I did everything and nobody listened to me, in which case then liability shifts to the foot soldiers. But either way, it's good for my client. And either way, if you were the plaintiff in an employment case, you want to know. You want to know because this is going to be a trial where everyone says this was my role, and we deny knowing about the whole. We deny knowing about the whole. This was not a concerted effort. Everybody was just doing their little job, and nobody's responsible for anything, because that's how this case has been defended and will be defended. And you'll hear the same arguments. You just heard them today. Jennifer Nancy is the one that signed off on it. Yes, she did. But if she's taking information from everybody else, if she's being told what to do, if she's being provided the information to make that decision, bad input leads to bad result. And that's that's the defense that they put up in these cases. And it puts us in a difficult position. And a lot of times we don't get to depose the director because I can never connect the dots. I can never go past Marsky. I can never go past Nancy. This isn't that case. This isn't that case. I have an employment case where the head of internal affairs is putting in writing page-long memos documenting concerns that are contrary to policy, documenting that investigations are being manipulated, documenting that there's very, very corrupt things going on. and I can't ask the person who's making the decisions. That's their position. I think this is the poster child case for when a director has to be deposed because of personal knowledge. Now, the Hamed case, Judge, this is what it would be like. In Hamed, where a prisoner got sexually assaulted, it would be like if the director of the prison was the one who sexually assaulted that prisoner. And then the court said, you can't depose the director. That's this case. Washington made the decision. She made the decision of termination. At least that's what the foot soldiers are telling me. So if she did that, then that would be like the jail director sexually assaulting the prisoner in Hamed and the court saying, you can go depose other people about the sexual assault. You don't need to depose the person who perpetrated it. It doesn't work like that. There's not a case in America where a person can have this, where a high-level executive can have personal decision-making and not be held liable. It would be like in the Toyota, the Alberto case, if the head of Toyota said, or the head of Ford said on the Pinto, go ahead, I'm going to sign this memo, go ahead. Well, it's cheaper to deal with the lawsuits than to fix the defective product. And then to say that you can't depose the person and say, why would you do that?
All right, gentlemen, I want to take some time to review what Mr. Asbenson submitted. I mean, I heard his arguments that frankly raised questions in my own mind that I've asked you. I want to go back and look at what he submitted before I make a ruling. And Mr. Marco, if there's anything in what he submitted that you want to add to besides what you said here today, I will give you that opportunity to respond. How much time do you? Go ahead.
If I can just respond to a couple of points very briefly.
Go ahead.
The first is I welcome you to please go ahead and review the transcripts, because there is no one who testified that Director Washington made any relevant decision to this case. And I'm going to go ahead right now and just quote 3 lines from Jennifer Nancy's deposition transcript. It's Plaintiff's Exhibit 7, page 17, line 7 through 9. He says, quote, "I'm the ultimate decision maker. I simply consult and confer with her, the director. And in this particular case, it was my decision to discharge." That's what.
And I heard you say that when you were making your initial argument, and that's why I asked Mr. Marco about that.
And then the one other thing is, I'll just mention that I'm looking at the Hamid case right now on Westlaw. There's 0 negative treatment of this case. Now, there's another appeal from Hamid, it appears, looking at the history, that does have some negative treatment, but not as regards to this particular decision. I see no. So I welcome the opportunity, you looking into this more further, and I appreciate it, Your Honor.
Yeah, Judge, what I think, by the way, Mr. Asbenson put on page 6 of his brief that Hamed was reversed on other grounds, specifically on page 6. So, well, the case was reversed. I mean, I understand that you're trying to hold on to that, but anyways, Judge, you can look at that. But I would like to do, Judge, if it would be helpful, and I don't want to overburden the court, but I'm looking at the deposition transcripts. I want to make sure that we provided you the entire transcript so you can see things in context. And if we didn't, could we supplement by providing the entire transcript for you? I don't know if you want that or not, Judge.
You know, I will tell you, I'm not going to read the entire transcript. I will only read what you asked me to look at. I've conducted and sat through depositions that last several hours, and I realize a lot of that questioning, although helpful, isn't germane to this particular topic.
Sure.
So I will read what you would like me to read, but don't throw a whole transcript at me and say, Judge, read it and figure it out yourself. That's not going to work.
I understand, Judge, and they're attached. So maybe I'll just have my office do a reply brief with the appropriate sites for you.
So let me ask, as I try to get my brain wrapped around your theory of the case, that your client engaged in protected activity. The protected activity specifically, and most germane to today's motion, is complaining to the director. But you've got a decision maker who's claiming it's my decision, who is also claiming I didn't have any knowledge of protected activity. I made a decision based upon the facts in front of me. I mean, is that what we hear?
Well, no, because, and let me explain that to you. And I found the testimony, and I can ask this court. I'll direct it, Judge, to Jennifer Nancy's deposition starting on page 17. And so this is what happens. Okay, it's like a mini police investigation and trial for these workers at corrections. This is how it works. Internal affairs is like the police. Okay, internal affairs is led by Stephen Marski. Internal affairs does an investigation of an employee, almost like a police investigation. They make like a police report, an internal affairs investigation. They attach all the exhibits that they get to that investigation, and then they submit it to the prosecutor, which is the director's office through Kathy Warner. So the first step in this is always the police investigation. Just like in the real world, if the police plant evidence, if they omit witness statements that are helpful to the defendant, or they do things in order to shade the investigation, it can change the outcome of the investigation. So sometimes in these cases, you have a bad investigation. And we have evidence in this case that there was a bad investigation from Stephen Marski himself, who said that people were interfering. Kathy Warner, who works at the behest of the director, was interfering with the investigation. That's step one. And that was what he complained about specifically with the police investigation. It's the internal affairs investigation, but it's analogous to the criminal investigation. Then there's stage two, which is like the trial, which is the prosecutor, which acts as Kathy Warner in conjunction with the director, who then determines guilt supposed to be based on the investigation, who can then ignore the investigation and just make their own decision, or they can rely on the investigation. So then that's like the trial, okay? And that's where the director steps in. And the director can step in on the police investigation because Marski reports to her. And that's what Marski says was the problem. Because he's a former police officer, and he said the problem was that people are interfering in other things that are supposed to be independent. The police investigation is supposed to be independent, but it's not, because Kathy Warner's coming into it and telling investigators what to do and changing decisions sometimes. Kathy Warner reports directly to the director. Then he said the second problem is then you have the decisions of the director and Kathy Warner. And then finally, the judgment. It would be like the criminal sentencing that you would do. That's the third phase. That is the phase by Jennifer Nancy. And so just like in a criminal proceeding, if you plant evidence on somebody and then they get convicted of the crime, that's going to affect the sentencing. Or if the recommendation of the prosecutor is really bad, that this guy has all these variables that warrant an upward departure in the sentence, that's going to influence sentencing. So by the time it gets to Nancy, if the process has been compromised, it's going to affect the outcome. And I don't know if that makes sense. I mean, so everyone has this role, but the problem with the director's office is it can put its hand in any of the role. It would be like, the executive branch coming in your courtroom and changing things around, telling you what to do here, telling the police what to do, telling the influencing the sentence. And I asked Miss Nancy specifically on page 17 about this. And she says policy ultimately gave her the authority to discharge, but that she has to discuss everything with the director. She said, I asked her, would you ignore the director? She says, no, we would discuss it. And then I said, and certainly you would respect if the director gave you different instructions or different input than you had originally come to the situation with. This is on page 17. She says, yes, we would discuss it. Yes. And then she says, I care about the director's input. I value what she tells me, and I would listen to what the director tells me to do. And I asked her specifically, Your Honor, on page 18, line 13, and wouldn't you listen to the director's counsel and guidance on a serious issue such as terminating an employee from employment, especially if they had devoted their whole career and life to the Michigan Department of Corrections? Answer, absolutely. And then I asked her whether you would take the termination to the director, and she says, it is this director's position. So, and I say directors do different things. She says, yes, but she has to consult with the director prior to a termination. The director has input into that termination. That's in her deposition, page 18. So it's very, technically Mr. S. Benson's right. Did Miss Nancy sign the form? And was that her job? Yes, she carried out the thing. But, that's like I was just following orders, right? I was just following orders doesn't insulate the person giving the orders. So,
But she doesn't really say I was following orders, does she? She doesn't say that the director influenced her decision, does she?
She says, I don't remember. She says, I don't recall the specifics. This is on page 19. That was quite a long time ago. She said, I would have explained my rationale for discharge. We would have discussed it. And then ultimately, obviously, the decision was discharge. I signed off as discharge. And then, so they had a meeting together and she doesn't remember. So I'd like to ask Heidi Washington what was said in that meeting. And, she, at the very least, she had a role in this discharge decision. And in these cases, I don't need to prove that she was the sole decision maker. I just need to prove that she influenced or was part of the decision-making process. If you have a group decision-making process, everyone's not insulated from liability. If you decide as a group to do something wrong, you're all liable. You don't get to say we're not liable because we made a group decision. It doesn't work like that. So, when we split hairs, this is the problem with insulating a particular person who has direct involvement. And this is why courts don't do it. This is why when there's direct involvement, not hypothetical, not esoterical, when there's direct involvement, that they always get deposed if requested. That's why Mr. S. Benson cannot find you a single case, and I challenge him to supplement a single case in America going back to the passage of the Civil Rights Act where a decision maker in a termination, because they're high level, is insulated from deposition. Nobody applies the apex deposition rule like that. Companies would just have the highest level person do all their firings, and then they could never be deposed. That's the type of argument that they're putting forward here.
Your Honor, I really wish that we had a process that was as able to be as independent as the judicial system and prosecutors and police officers. But what we have is Stephen Marschke as head of internal affairs, and he doesn't report directly to Director Washington. He reports to Kathy Warner. Kathy Warner is ultimately responsible for IA. And so I find it really interesting that Mr. Marco keeps saying that Kathy Warner meddles in IA. It's part of her job description. That's her job.
All right, gentlemen,
All right.
I've got to move on this morning. Mr. Marco, how much time do you need to file a supplemental or reply brief?
Judge, I am leaving for out of the country next week, so could I have 14 days or is that too long?
I'm fine with that. I mean, we're not up against a trial deadline, gentlemen.
No, we do. I think we extended discovery through April 22nd, I believe it was. So we may need to bump that date again, just
And
depending.
that's fine. I don't know if you've heard, but we've been moved back to phase 2 in Jackson.
Okay.
So that just kicks out that much farther a realistic date as to when I'm going to be able to start doing jury trials again. So you've got time.
Okay.
Judge, I just would note that Mr. Espenson, when did we schedule facilitation for?
We have an initial, it's basically a phone call to schedule the actual facilitation, but it's April 12th.
So Judge, we've agreed that if you do order the deposition of Director Washington, that we will hold that in abeyance until after facilitation. In other words, if let's assume that you grant our motion to compel the deposition, we've agreed to go and try to facilitate before the director's deposition. In other words, so if we can resolve the case, she won't have to sit for a deposition. So if it's possible to have a decision before the facilitation, I think that would go a long way in helping and motivate the parties to resolve the case.
So you're going to meet with, or speak with the facilitator to find a date as to when you can facilitate.
Correct.
All right. Well, if you pick a date before this matter is in front of me for decision, and that's going to be at least 2 weeks away. If you need 2 weeks to reply, just tell me what it is.
Okay.
I'll make sure I
Okay.
take a good hard look at it so that I can get you that decision before your actual facilitation.
Thank you, Judge.
Thanks a lot, Your Honor.
Thank you, gentlemen.
I appreciate your time this morning.
Have a
You
good
too.
weekend, Judge.
You as well. Happy.
You too.
Okay, I think I'm ready for Robinson versus Griffith, but I'm trying to figure who in my waiting room is here on that case. So, Mr. Doyle, you can hear me?
Yes, I can hear you, Jan.
And obviously, Ms. Griffith is present. The two other names of people in my waiting room are Battersby and Murray. Do those names sound familiar to you, Mr. Doyle?
No, Your Honor.
All right, I see now Battersby is on a different case. Are you expecting somebody else to appear today?
From the plaintiffs, yes, Your Honor. Miss Nora Hanna was expected to appear today.
Is she an attorney?
Yes.
She's not in my waiting room right now. So I'm not sure what's going on there. Can you, so you're expecting that she would oppose This is a motion to compel a deposition, is that correct? No, I'm sorry.
Uh,
Yours is a motion to set aside a default.
Yes, Your Honor.
And I apologize, I'm working from home. I don't have the court files. My departure from the courthouse was sudden because we had an exposure and I had to come home and quarantine. So whose motion is this, Mr. Doyle?
It's my motion, Your Honor.
All right. And, well, let's see. I wonder if it's possible that Mr. Murray is from the office of whatever other attorney you were expecting.
Oh, Feiger's law.
Let me let him in and see what matter he's here for. I don't see his name on my list. Mr. Murray, what matter are you here for today?
I'm here for the Mariah Woods matter with Mr. Battersby.
Okay. All right, so Mr. Doyle, I'm going to put you and Ms. Griffith back in the waiting room. If you could double check and see what's going on. It could be the other attorney is stuck in another courtroom right now. I haven't looked at my email. I might perhaps have some communication, but since I've got both parties here on the next matter, I'm going to go ahead and hear that while we're trying to figure out what's going on with your case, okay?
Yeah, yes, Your Honor. Thank you.
Okay, gentlemen, you're both here on the matter of Woods versus Gibson.
Yes, Your Honor.
Yes.
All right, and this is a motion to compel Ms. Gibson's deposition and to adjourn the scheduling order dates.
Yes, Your Honor.
I'm assuming there's a jury demand in this case.
There is.
I have no idea when I'm going to be able to start doing jury demands, so I've been pretty generous on extending dates. Our courthouse just went back to phase 2. Our community has seen a significant surge in positive cases. I'm actually working from my dining room today because I had an exposure in my courtroom that requires me to quarantine for 10 days.
Oh, really?
So I'm feeling fine, but I got to follow the rules.
Sure.
So here I sit in my dining room.
Well, and it looks good, Judge, on camera.
You can't see how messy the dining room table is, though, unfortunately. In terms of extending dates, I'm happy to give you whatever you need in that regard. My best prediction is maybe sometime early fall, I might be able to start doing jury trials again, but we shall see.
I had a settlement conference yesterday with Judge Kunke in Washtenaw County, and I got a trial date of February 7th, 2022.
Wow. Well,
They're not really sure it's gonna go.
I'm not scheduling new dates. I mean, as new cases get filed, they automatically get assigned a date. But in cases where I'm just adjourning because we're not ready, I'm not even giving new dates. I'm not going to put my staff through the process of finding a date and then having to cancel it again and renotice everyone. So what I'm doing is setting a pretrial at a date when hopefully I will have a better picture of what the future looks like. And I'm hoping things turn around here in a couple of months as more and more folks get vaccinated.
Yeah,
And if that indeed happens, obviously that's going to dictate how I schedule things. But
sure.
and I'll be taking the cases in pretty much order of their age. So anyway, so don't worry about the scheduling order. I'm happy to deal with that. Let's talk about the compelling the deposition.
Judge, if Brother Counsel and I talked last night and we tried to work things out, and we were able to work a few things out. We've gotten the authorizations to them that they requested, and he agreed that he would concur with adjourning the dates to 90 days, and apparently it's not any problem for you either. The only remaining issue is the defendant's deposition. The defendants, for some reason, which is kind of odd to me because I've been a trial lawyer for 38 years. I've handled over 4,500 personal injury cases. My entire career was either working with Jules Olsman or Sam Bernstein for 36 years. And I have never had anybody on a dog bite case suggest that the depositions were going to take 4 to 5 hours. I've tried more dog bite cases than I care to remember. Typically speaking, obviously, the only question is whether or not there was a bite that occurred that was unprovoked and whether or not there was any type of trespass or other defenses. There is nothing like that in this case. The defendants are insisting that we take the depositions on separate dates, at least 14 days apart. And it's kind of odd because we have a detailed police report on this case. It makes it very clear what happened in the case. There's simple medical treatment, which has already been provided to the defendant with detailed photographs of the scars. So it's more like the depositions of all three parties will take an hour, maybe 2 hours at the most. We have initial disclosures that both parties already provided, which we're now required under the court rules to tell people right away, whether they ask or not, what our defenses are or what our claims are. That's already been done. As I stated, the police report is already detailed. This dog had prior bites, so this was a criminal action as well. The plaintiff was just a minor who was visiting the defendant, and the defendant had her dogs roaming free in her front yard and off the leash, and one of the dogs attacked her from behind unprovoked. So the very notion that the defendant thinks that I am somehow, venally trying to obtain some kind of an unfair advantage by taking the depositions on the same day is ludicrous. The fact of the matter is that I shouldn't have to reschedule another day just to take maybe a 15, 20-minute or a half-hour deposition of a defendant. And we've been trying to set these depositions since late November. So, I understand that other people have different notions about how to defend the case. There is no defense in this case. But even if there was, I have never had anybody who insisted to have the depositions on different dates. I just merely want the depositions at the same time because it's good for housekeeping. It means we don't forget the deposition of one party or so forth. We take them all, we put them aside, and that part of the case is done. And Judge, I'm sorry to have to bring you into this, but I can't get anywhere with counsel for the defense. And I'm not talking about counsel who's here, but rather his associate Allison, who is on this case as well. I don't understand her position. I've tried to get her to. I've called her to talk to her, and I did talk to Jeffrey Murray, but we were unable to get that over. So we just said, well, let's just let the judge decide how we're going to proceed in that regard.
So I got the impression, I did read this yesterday, that one of the issue is the order. The plaintiff should be deposed first and then the defendants. I mean, is that a battle here?
No, Judge, that's not the truth. The funny thing about it is that I attached emails. We agreed to go forward with our client and our client's next friend's deposition. We just wanted to take the defendant's deposition when we were through with them. I've never tried to get a change in the sequence and timing of the.
What was your plan for how you're going to do the depositions? Are you going to be doing them by Zoom or?
Yeah, we've agreed that Zoom is a proper way to go.
And how is that working these days? The deponent shows up separately or shows up at the office of the court reporter, or logistically, obviously I've not been practicing law in quite a while. I'm just curious.
Judge, I've been doing this since March 13th, 2020. I came home. By the way, it was Friday the 13th. So, but I have not had anything but Zoom deposition since that time. And more often than not, the people either use their smartphone or they use their laptop or an iPad or something, and we take it that way. We've done it without a hitch for well over a year, and it's easy to do. Most court reporters have it down pat. At the beginning, there is a court rule that indicates the court reporter has to be in the same room with the deponent. In order, obviously, to make sure that the witness is properly identified and is doing what they're supposed to do. But most attorneys since probably about last April of 2020, have waived that and have said, yeah, we understand, we agree. And it's okay for the court reporter to do it by Zoom. So, yeah, I think it's been very easy. As a matter of fact, we, just before the holidays last year, I'm a member of the American Board of Trial Advocates, and Justice McCormick talked to us. And one of the things she talked about was even before the COVID crisis, the Michigan Supreme Court was moving towards doing things more on a remote basis like we're doing right now. And not just in criminal cases for arraignments and so forth, but just to make the costs of litigation go down, make more access to the courthouse for other people, because it's tough for a lot of people to get up and travel and get to the courthouse. And so, in fact, you were exposed to somebody who may have had COVID, But anyway, Justice McCormick was saying that she thinks that the way things have been going, and by the way, there is a court order that says if you can do it by remote, you must do it. And that comes right from the Michigan Supreme Court. She says that she thinks the future is going to be more like this, and it's going to be encouraged by the Michigan Supreme Court. So
that leads to my next question, which is, if you're doing them remotely, I understand if you're traveling to Jackson and all the witnesses are here, that you don't want to make 3 trips to Jackson or wherever it is. Let's get them all done on the same day and save some money. If you're doing them remotely, why is that such a significant sticking point?
Well, here's and I would ask you just to think about this a little bit. I have a wrongful death case up in Mecosta County, okay? And we took all the depositions in the same day. And all the parties basically testified about what happened. And then we had a facilitation about 4 months later. And the defense attorney started coming up with notions about defenses that her client completely ruled out in his deposition. And it was because of the fact that everybody was just looking at the case squarely as it was and putting their testimony on the record and moving on. And that issue's done. Now, Sister Counsel even puts in her response that she needs an opportunity to sit down and talk about potential defenses. Judge, if she doesn't know what the defenses are based upon her initial disclosures and the police report and already talking to her client, I don't know what she's going to get out of my deposition other than coming up with some notions like I'm talking about on the case in Mecosta County. That the defense attorney in that case is not going to get away with it because her client already laid it all out and said, nope, there's no reason why I ran that stop sign, killed the plaintiff's decedent. Likewise, in the instant case, if we take the depositions coolly, write it one after another, and she has an opportunity to sit there and listen to my client's testimony, she does because she's a party. That's all very fair, but then she needs to give her answers right then and there without having some kind of concoction over 2 weeks or a month with the defense attorneys, which is what they say in their answer they want to do. So I agree with you on the point that there's more compelling reasons when you have to travel and spend a lot more money and all the rest of that stuff. No doubt about that. But still, this is Judge, I don't want to be too inflammatory or anything, but it's ludicrous. It's a dog bite case, you know, and there's no reason why it's necessary to set aside 2 days for a dog bite case. This deposition should be over in an hour to 2 hours.
All right, go ahead, Mr. Murray.
Yeah, so the reason why, and that's been kind of glanced over here, these depositions were all noticed around March 1st to happen on the 23rd. Allison, who's the senior partner on this case, had a conflict arise on that day. She's got a young child. Her child's school got canceled due to COVID. And so suddenly she's got a 5-year-old doing learning at home. And so the idea of having these marathon deposition sessions on one day, when, as we've discussed, doesn't have to happen, posed some significant childcare questions. I'm in a similar boat. I've got young kids. The idea of having 3 depositions in one day, which, as Mr. Battersby said, might take a half an hour, but they also might take a couple hours. And that's perfectly appropriate in a case like this, to have those marathon sessions in the current environment, particularly where the defense attorneys both have little kids and lots of challenges surrounding childcare, was too much. That's why we suggested, let's have plaintiff and the next friend go one day, and then sometime in the next 2 weeks after that, we'll find a good and mutually agreeable day to do the defendant. I do also think that defendant has an interest, and this is supported by the court rules, in hearing plaintiff's proofs in detail. As I'm sure you've seen from initial disclosures, they are typically quite pro forma. They are not detailed in the least. And the deposition is often the first opportunity that we have to hear it straight from the plaintiffs as to what the particulars of their claims are. It's perfectly appropriate for plaintiff to put forward their proofs, allow us an opportunity to understand them, to confer with our client, and within a day or two, we'd then be happy to produce defendant for deposition. That allows us to proceed in the way that the court rules support, and it also addresses the child care issue. That's the reason why we couldn't agree to this do it all in one day proposal that Mr. Batteries has been pushing. And so we're just asking for, a modicum of leniency to do the plaintiffs in one day, and we'll come back a few days later and do the defendant.
Your Honor, if I may, real briefly.
Go ahead.
The court rule says that the timing and sequence of discovery cannot be controlled by any party, and that one person's taking discovery does not change where another person can take discovery. Now, Judge, again, since March 13th, I've been doing this. I've had lots of people who've had kids who are at home being homeschooled and so forth, or remote schooled, I should say nowadays. And Nobody's ever raised this before. This is a simple dog bite, Judge. This is really.
All right, here's, I mean, this is really the stuff I expect attorneys to work out. Here's what I'm gonna order. The depositions will occur over 2 days, back to back. The plaintiff will be deposed the first day and the defendants will be deposed the second day. You need to find those 2 dates that work on everybody's calendar. Mr. Battersby, you prepare that order?
Yes, Your Honor. May I also put in there that we've adjourned the case of Al for 90 days?
Yes. In fact,
Set by the court.
anything, any dates that you want extended, just include in this. Give us your current date and then a blank for the adjourn date.
Okay.
It will supply that. And like I said, I'm not going to schedule your trial, but I will schedule a pretrial so we can get our heads together and figure out, all right, when can we set a realistic trial date?
Thank you, Judge.
All right. Have a good day, gentlemen.
You too.
Thank you, Your Honor.
Okay, hopefully everyone's here now on Robinson versus Griffith. Is that correct?
Yes, Your Honor. I am so sorry about the mix-up. I'm so sorry.
No problem. Mr. Doyle's the only one that had to wait. I was here anyway.
Then, Mr. Doyle, I apologize.
Oh, no problem.
Then Ms. Griffith, okay. And Mr. Doyle, this is your motion to set aside a default and a default judgment.
Yes, Your Honor. Initially, we rely on our motion in brief. This is a situation where a default was entered against my client in February of 2020 in the amount of $500,000. We believe there's good cause to set aside this motion. And basically, it's a situation where we had a layperson who believed that she was doing what she was supposed to do, but obviously didn't. And then she didn't receive any further notices because her house had got foreclosed on, and essentially she didn't get any notices of the default, and that's why we're here now. So, as far as a defense, because this is a third-party case, we understand that the plaintiff has the burden of proving that there's a serious impairment of important bodily function, which we would contest if this matter was to proceed. And that's all, Your Honor.
So the good cause that you're asserting is Ms. Griffith didn't understand the importance of responding despite the fact having received a summons that says you got 21 days to answer or defend this matter. You're not claiming she didn't get the summons, correct?
No, we're not claiming that she didn't get the summons. We're claiming that she believed that she was doing what she was supposed to do when she actually physically appeared at the court. She thought that that was her appearing instead of actually writing down a written answer and moving it according to the procedure, Your Honor.
When you say she appeared at the courthouse, what do you mean? Was there a hearing or something, or she just show up at the door?
She indicated that she received notice of a hearing. She went to the courthouse and then was informed by court staff that there was no hearing and she was free to go. And after that, she hadn't received any notices.
Well, we don't hold hearings within 21 days of filing of a summons and a complaint. I can't imagine what hearing it would have been that she would have attended. I'm certain there wasn't anything scheduled at that early date. We do have, in my business case, well, let me think for a minute. We have different scheduling orders. I'm just trying to think. Yeah, I'm not aware in any of my scheduling orders there's any automatic appearance date involved. All right, Ms. Hannah.
Your Honor, case law already defines what good cause is. It needs to be a substantial defect in the proceedings. The defendant already admits that they were probably properly served with the summons and complaint received the copy of the lawsuit with the summons that indicates that an answer and appearance is necessary. This case is from 2018, 2019 timeframe. I never to this date received an answer or appearance from the defendant. We did have a motion for entry of default, Your Honor, twice. Notice was sent, and I don't recall anyone being there. And I don't want to misspeak, but I don't recall that. I remember my client, his son, and Your Honor made arguments as to his serious impairment, but I don't recall anything from that perspective. And I mean, that's at the time we've already entered the default. So when we talk about just the entry level failure to appear and give an answer, that just never happened. Not knowing what to do is not good cause, especially when there is a summons and complaint. There's also a helpline through the state of Michigan. And the second point is the affirmative defense, or the justification that there is an affirmative defense. Your Honor, the police report we attached as an exhibit, albeit it is a hearsay document, gives us an idea of what happened. My client's not at fault. I don't think they raised the fact that he's at fault. He clearly had a serious impairment. His body was fully casted. At the time we entered the default judgment, we did provide medical records to this court. Your Honor did read those records and issued a judgment based on not only the voir dire testimony of myself and our client, but also those medical records. This is now almost 2 years after the fact. There's absolutely no good cause to set aside a default this late in the stage, especially as defined by the case law we relied on in our brief.
All right, I'm going to deny the motion. I don't believe there's been adequate grounds stated for setting it aside, and more importantly, the time frame. This is just way too late in the process. I'm going to deny the motion. Ms. Hannah, you'll submit an order to that effect?
Sure, Your Honor, no problem.
Okay, thank you. That concludes our hearing.